Good morning, good afternoon, good evening, depending on what part of the world you are in. This is the Big Girl Diary. Oh man. Oh, I got a massive update for you on Marilyn Manson. And his lawyers, ooh, they got it all planned out and they're bringing the heat. I'm in a white room. So we got a lot to discuss, but I'm going to condense it. And keep in mind, I'm not a lawyer. I have $2.50 worth of understanding of law. Okay? Now, Marilyn Manson's lawyer submitted a declaration to the courts that talked about two things. Oh, pure fire. He talked about the plaintiff's unopposed ex parte application that was for September 13th. Also included the continuing of September 13th, the anti-slap hearing. So you got those two things. And he brought the fire. Oh my goodness. And the background between the lawyers, Illma Gore and Evan Rachel Wood's lawyers were like, let me slow it down here. So keep in mind, ex parte simply means a meeting, the lawyer of whether if it's the plaintiff or the defendant, it doesn't matter which one, has a meeting by themselves with the lawyer and the other team or the other side knowing about it. So it's not like that anything is being secretive. And it's always to get a temporary order of some type. Okay, now it gets good. Let me go through the little muck first. The declaration. Now he says, and the dates are very important. You're like, Big Girl Diary, really? Yeah, they're important. So that you can see the flow of things. Okay, now this July 22nd of 2022, the courts permitted Marilyn Manson to file a motion seeking limited discovery necessary for the defendant's anti-slap. So he was already granted that. They filed it July 25th. The court set a hearing on August 18th, and the hearing and defendant's anti-slap motion for September 13th. Now, when he filed for that, it was good cause. So when he filed that on the July 25th, it came back on the 18th. Good cause. So they're laying the groundwork. So let me see. Now, Warner's opposition to Evan Rachel Wood and Illma Gore's anti-slap motion were due August 30th. They already got that covered. Okay? 9 days prior to the hearing. So all that's done. Don't worry about it. Mr. Trugman, oh, he is on his P's and Q's. Now, this is what he discovered on August, let me see. Okay, August 18th. That happened, what? Last month. The court needs additional time to rule on the motion to conduct a limited discovery. Consequently, the hearing thereon will be continued. No appearance is necessary. The clerk will be in contact with parties to discuss a new hearing date. Pin that right there. Just pin that. Because that came out of nowhere. Now, Trugman says in his declaration, following August 17th order, I called the Department 50 on August 22nd and 23rd to ask whether there was a new date. And a new date set for August 18th hearing. I had not heard from the clerk. I was told that a date would be set and no date appearance to be set on line docket. There was nothing there. So Warner will immediately be, and because of this, and this right here can cause him a lot of problems. So Warner will immediately and irreparably be harmed if September 13th hearing are not continued, regardless of how the court ultimately rules on discovering motion. It doesn't matter whether they say yay or nay, they just need it. Now, if discovery motion is granted in full or in part, Warner will have already prepared and submitted his oppositions with the benefit of the discovery. In the event the court were to deny the motion, Warner would have already opposed the anti-SLAPP without having seen the court's analysis on several legal issues raised by both the discovery and the briefing. Remember, they laid everything out beforehand, and his lawyers are on fire. May I get the boy say, oh man, they are just. If the discovery motion was granted, or if the discovery motion is granted in full or part, Warner would have already prepared and submitted his opposition. Okay. Without the benefit of such discovery. In the event the court were to deny the motion, Warner would have already opposed the anti-SLAPP. Here's the interesting part. The defendant's anti-SLAPP motion, and without having been able to argue those issues at the hearing on discovery motion. Now, August 23rd, I provide notice of the ex parte. Keep in mind, the judge already gave good cause. That's in good cause. The judge already ruled on that. I received response from counsel for defendants. True, incorrect, and he goes into saying this. Now, this is where the fire hits. Now, Jackie Zemanek, that I believe is Illma Gore's lawyer, and what she says to Jackson, or Mr. Trugman, she calls him by his first name, Jackson, without waiver of the position of our opposition papers, we do not oppose the short continuance on the 13th. They're saying it's okay. It's okay that they continue this. It is all right. Jackson responds back to Maggie saying, we haven't heard anything from the court. Now, I'm going to skip over some things because this go back and forth. Now, this, is where the fire hits. Michael Clump. Now, I'm not sure if this is Evan Rachel Wood's lawyer, but he says to Mr. Jackson Trugman, Marilyn Manson's lawyer, he says, as demonstrated, okay, Wood's lawyer, as demonstrated in Wood's opposition to plaintiff's motion to conduct five depositions before September 13th anti-SLAPP hearing. You did 5 depositions before this hearing. Oh. Hear all the women scream. Ah! Oh my goodness. The plaintiff has failed to establish any good cause for allowing those depositions before the hearing. Oh, they're peed. Wood's lawyers is upset. He got these depositions. They laid all this groundwork while Evan Rachel Wood saying, I graced you with my presence. Oh, I don't want to sit down for a deposition. It's too much. I can't do it. You want me to sit too long. While Marilyn Manson's lawyers are just like, bam, getting these depositions in, got 5. They got what? 0. They're upset. So, he said, you failed to establish good cause. Oh no, we can't have that. We can't have that. And then it further says, for showing those depositions before the plaintiff's motion. So they got all this laid out before he even asked for the limited the limited discovery. He has this already in place. So whatever the courts do, he has all his bases covered. It doesn't matter. All the bases already covered to what they can say. Yay, nay, yay. So if they say nay, then they got that. If they say yay, they got that and that. So his lawyers got everything covered. So goes on to state, the statute and case law are clear that Wood's anti-SLAPP motion should be given priority and heard at the earliest possible date without waiving any of Wood's positions. In arguments, her briefs were not opposed a brief continuance on September 13th. They don't have a problem with the continuance. Their problem is, oh, we didn't see this coming. This Mack truck get ready to run us over. Fire. So, Mr. Trugman responds back, saying we haven't heard anything from the courts, but he said, accordingly, we intend to move ex parte for an order continuant on September 13th on the grounds that the plaintiff's opposition to the anti-SLAPP motion are due on August 30th, and the court has not reset the discovery motion hearing ruled on that. Oh, is that it? Oh, well, we're still going to do the ex parte that we got good calls for. We got good call. Go back on my videos and you'll see. Last month, the ex parte was granted. I showed you pictures of it. Oh, man. Now, I know their faces are tight. I know it's tight. So, he goes on to say, we intend to appear Thursday morning at 8:30 a.m. virtually unless September 13th hearing are reset by the court in the meantime. So they're going to go ahead and go anyway. Unless if anything happens, they're going to be there. And then if they say, okay, no court, okay. Oh man, oh man, oh man. Pure fire. And I will most definitely put the declaration to where you can see it. A massive update. Now, no matter which way it goes, Marilyn Manson's lawyers are there. They got all bases covered. Wow. Wow, wow. I want to feel bad for Evan Rachel Wood and Illma Gore. Let's feel bad for them for 1 second. Okay, we're done. They brought it on themselves. Oh man. Once they get past this hearing, and Marilyn Manson needs it to enact everything that they put down into place. And once this hearing is done, a couple of more steps, I believe, but then it's going to be the courtroom. Explosion. All right. Based on that update, what do you think? Put something down in a comment section. This was pure fire. Fire, fire, fire. I want to thank my subscribers. I want to thank you for hanging in there with me, because time is something that you can never get back. No. You could always get your taxes back. It might take you 20 years to get that loan back that you gave to your cousin. I didn't want to give it back, but then finally did. But you can never get back time. On that note, I want to thank all of you for stopping by.